links to the different programs. And Matt Margolis has been doing this with me through the Y for the past 3 years. He was one of my very first adult education series presenters and has been a steadfast part of the adult education series community every single month, except for over the summer for the past 2 years. And then this year, he even has been doing them over the summer virtually. He just transitioned right with us to do virtual programming. If you miss it this week, you can join us again next month. And if you've got a question about something that he might have talked about this week that you didn't think to ask, you can ask about it next month. He's really good about sort of going beyond the edges of perhaps what the topic is about, but he will try to stick to the topic for the most part when he's speaking. He is kind enough to take questions throughout the program. So if you have a question, you can just ask, or if you, maybe I'll ask everyone to mute yourselves unless you have a question so that we don't get the extraneous background noise. Matt's going to be recording the program today, so it will be up on the WISE website in our podcast section of the adult education series. And that way you can watch it at a later date, or you can refer someone else to it and say, hey, I watched this great program with this excellent elder law attorney through the Y. Go to the WISE website and go to the adult education series and watch the podcast, because I learned so much today, because you will learn a lot today. I am actually going to have to cut out of the meeting. I've got a personal thing that I need to attend to. But I wanted to be here to welcome Matt, to welcome all of you. Thank you all for coming today. I never know how many people we're going to get. So it's always a pleasure when we get a screen full of people. So thank you for joining us. Tell your friends. Matt's always what is today? The first Wednesday of the month at 9:15. And again, you can find him on the website. Matt, thank you so much for doing this. He is a wealth of knowledge. He's very forthcoming. He does ask that you don't ask personal questions, but I'm sure he'll explain that as well. Because you don't want everyone knowing your business. But he also will take a phone call afterward because he's so generous with his time. So again, thank you, Matt. Thank you all for being here today. I'm going to exit the meeting. He's going to record it. So remember, it will be recorded and up on the website. Remember that when you're thinking about your questions. And thanks again. Have a great day, everybody.
Thanks, Karen.
Thank you.
All right. Good morning, everybody.
Hello.
And actually, I started recording this about 2 minutes ago. So Karen, your whole spiel is up on the WISE website. It's going to be up on the website. So good morning. Glad to have everybody from the comfort of your own homes. For better or worse, I actually love some of these talks. Love doing the talks this way because, you know, we can all kind of be comfortable, sit in our houses. If you're like me, you're not wearing pants. I'm just kidding. So, you know, today's topic, honestly, it probably won't be a full hour, probably be 45 minutes or so. But just to give you my, sort of my 2 cents up front. So my name's Matt Margolis. As Karen mentioned, I've been doing these talks now for, I guess, consistently, every month or so, other than the summer, for the last 2 or 3 years. But I for sure know I've been doing them for at least 4 years, because I can remember, at driving in and being in the Y parking lot and talking to my older sister the morning that I found out that our current president was elected 4 years ago. So I know for sure I was doing talks 4 years ago. It's a memorable morning, no matter what side of the spectrum you're on. So, but we're not here to talk about that today. My partner and I, Lauren Weldon, have a boutique elder law and estate planning practice in downtown Park Ridge. I don't know if Karen mentioned, I am a Northbrook resident, so you guys live around here. I do too. And our firm helps people with estate planning in the sense of wills, trusts, powers of attorney, special needs planning, asset protection work, probate. We do powers of attorney for 18-year-olds going off to college. And then on the elder law side of our practice, we have a strong focus on asset protection and helping people apply for Medicaid. So a few of you, I'm muting everybody just so you know. So if you're getting muted on your end, if you can please keep it that way. There's definitely some background noise, especially, I'm not sure who's calling in, 847-647-8004. If you can just keep it on mute. If you have a question, so, my general spiel is if you have a question, if I can see you when you're showing your video, raising your hand will be awesome. And I might give you like one of these with my finger, and I'm not trying to be rude, but you know, if I'm kind of in the middle of my train of thought, I just like to finish, because if you're like me, I'll forget. It takes me about 2 seconds to forget where I'm going. And if I cannot see you, then obviously you can unmute yourself and maybe just say, you know, I have a question, and I might just say, you know what, give me a second. Again, not trying to be rude, but I want to make sure that I finish whatever train of thought I'm on. So, and lastly, like Karen mentioned, really let's try to stay away from any truly personal questions. And typically that means like, you know, anything that's like my mom, my dad, my sister, my brother, my husband, my wife. Inevitably, I give this disclaimer and those questions come up. It might just be depending on the question. I may or may not answer it, just to be really upfront. I'm happy to take questions at the end. I've definitely got until 10:15 blocked off on my calendar. So if we need the time, we've got it. And I will put, so there is a chat box here, and I'm going to go ahead and put my contact information in there, just so if you would like to reach out with a phone call, you know, if you have a question or you want to shoot me an email, feel free to do that. I can definitely promise you that I will not be available today. I've got a pretty booked schedule, but feel free to email, call me whenever. I will get back to you, I promise. All right, that was a mouthful. I'm sorry for all that housekeeping. Let's get started. So, discussing important documents. You know, I think that in general, a lot of us, when we think of estate planning and we think of important documents, I feel like for most of us, I think the first place we sort of go to is this idea of wills and trusts. And don't get me wrong, those are extremely important documents. Those are not documents we're going to talk about today. It's not on the schedule. There are plenty of talks I give throughout the year where I touch on those. But you know, really, to me, I mean, I think some of the most important documents that people can have are powers of attorney. And I think that a lot of time these sort of get minimized. And I think they get minimized because I think people tend to be like, oh, well, we can just print those online, right? We can just find copies online. Or I've had clients, and I didn't even know this until a couple of years into practicing in estate planning, elder law. I'd have clients come to me and they were like, oh yeah, you know, they brought me powers of attorney for their mom or dad. And, you know, they went and they got forms at Staples or Office Max or Office Depot. And, you know, so, and sometimes, you know, these documents are just signed at the hospital, right? So if anybody on this call, or if you've had a loved one go to the hospital and have any kind of procedure done, it's not uncommon for the staff there. First of all, they're typically going to ask, do you have a healthcare power of attorney? And if you don't have one, a lot of times they will have you sign one in the hospital, right? And they've got their forms. Those forms tend to be about 10, you know, anywhere from 5 to 20 years outdated. But at least they've got forms there that you can fill out, and they will get the job done. Okay, I'm not saying that they won't. And that's important, right? Because if we're having any kind of procedure done, any kind of medical procedure, and something were to go wrong, clearly we want to make sure that we've got somebody that can make medical decisions for us, right? And so I'm glad that the folks at the hospitals and whatnot are making sure that people are protected when they're going in to have any kind of work done. So let's talk about powers of attorney first, right? So in Illinois, we have 2 types of powers of attorney. Last thing I'll say before I get started, I see some of you look like you're taking notes, which I love. I would definitely love you to take notes. The one thing I will offer though is if you shoot me an email at any point in time, I can send you sort of an outline with a lot of the information that we're going to discuss today. I can definitely promise you I'm not looking at anything as I'm talking, so it's not like I'm going exactly off my outline. But I'm just throwing that out there. So I'm not saying don't take notes, please do. But if you do want an outline with some more detailed information to kind of back up your notes, just, you know, as I said, I put my email in the chat box. You can shoot me an email. I can send you those. So in Illinois, we have 2 types of powers of attorney, healthcare and property. We'll talk about healthcare first. So healthcare power of attorney is a document that we're putting in place to ensure that if we get to a point where we can no longer make our own medical decisions, we're naming somebody that can step in and make those decisions for us. All right. In Illinois, we can name as many people as we want on healthcare power of attorney, but we can only name one at a time. Okay, there's other states that allow people to name multiple agents, right? You can, I think Indiana, I feel like I should actually check into this, but I've had plenty of clients come to me from Indiana with co-agents named. And let's just say in general, there are other states where people can name co-agents, right? So I can name my son and my daughter as co-agents on my healthcare power of attorney. So if I become incapacitated, they can work together. Illinois doesn't allow that. And there's a lot of things that Illinois does that I don't agree with. But this would be one that I definitely do, right? I mean, I love the idea that it's one at a time. I think that having two people named at the same time to make medical decisions is a recipe for disaster, personally. Because even if I make my medical decisions very well known to my adult son and my adult daughter, if it comes a time where they have to make a pretty serious decision for me, what if they disagree? Right? Even though what my daughter is saying is exactly what I wanted, my son is having a hard time with that, right? Maybe he doesn't want to let me pass away. Maybe he wants to hook me up to machines, right? I mean, clearly I would hope both of my children would want to keep me alive as long as possible. But at the same time, we want whoever we're naming, whether it's a spouse, whether it's an adult child, whether it's a niece, a nephew, a good friend, a care manager, whoever it is that we're naming, we want to make sure that they're making our decision. Okay. And, and this is important. I mean, I have clients all the time that say, oh, they talk about one child of theirs and, oh, my daughter is so sweet and so loving. And I think that she would be the right person to make medical decisions for me. And a lot of times I'll respectfully challenge my clients and say, well, if she's that sweet, if she's got that big of a heart, if she's that warm, and you don't want your life artificially prolonged, is she the right person? Would she be able, would she have a really hard time making that decision? Would you be putting your daughter in a situation where, yes, she knows what you want, but she may not be able to she may not be able to do that. Clearly, when we think about medical decisions, we all go to that last decision, right? We don't think of the sort of everyday medical decisions where if I had dementia and I could no longer make my own medical decisions, literally my agent, the person I'm naming, is going to step in and make all those sort of regular daily medical decisions we have to make for ourselves, right? As simple as, do I get a flu shot this year? Is this the right, is this a prescription? Is this a prescription drug I should be taking? Do I undergo this, minor elective surgery? Right? Those are sort of the more common, more everyday decisions that most of us don't really put too much stock into for the most part, right? We all go to this place of this end of life decision, right? The proverbial pull the plug decision. But knowing that is likely the toughest decision that we're dealing with, I think it does make sense that this is what we get hung up on. This is what we have to put a lot of thought into and talk to the people that we're naming to make sure that they're comfortable ultimately making that decision for us, right? Because it doesn't matter if it's my wife who I've named first on the power of attorney, or my brother who's named as the fourth person in line on my power of attorney. At some point, I think it's important to have a discussion with all four of them or all five of them and let them know how I feel. And it doesn't have to be, at during a holiday Zoom dinner, that we're all going to have this winter. It doesn't have to be, I'm not suggesting that we do it during then, but we should have a conversation with the people, because number one, we want to make sure that they're comfortable making that decision. And if they're not, then maybe we shouldn't be naming them. Why would I want to potentially put this person that I care about in a really tough spot when I know that they just wouldn't be comfortable making that decision, right? So it's a blessing knowing that they would make that decision for us, and it's equally a blessing for them to tell us that they would not be willing to make that decision for us, that they would have a really hard time. Great. Maybe there's one other person that I can think of that I would name then rather than you, right? I appreciate being told that. So again, we just want to make sure that we're talking to the people that we're going to name, and just make sure that they're comfortable stepping into those roles and making those decisions. The reality is that on the power of attorney for healthcare, I get to make an election, right? I get to check a box that says, I value the quality of my life over the quantity. Or in the opposite direction, I value the quantity of my life more so than the quality, right? Do whatever you can to keep me alive. It doesn't matter how crazy experimental drugs you want to give me or how many machines you want to hook me up to. I want to stay alive as long as I can, no matter what. That's great, right? The beauty of this is that we all have a choice and we all get to decide what we want. But the reason why I suggest having a conversation with the people that we're naming is because the last thing I want is that if a really difficult decision had to come up, the person that I've named is looking at a box that I checked on a standard form, right? I'm not speaking from experience, but I can just imagine that, if I had to make that decision for one of my parents, it will be easier for me. I know what they want, right? If the first time I'm finding out what they want is while they're in a serious medical condition and I'm simply, rifling through a document that they signed 15 years ago and a box that they checked, maybe it's a harder decision for me to make, right? Maybe the attorney pressured them to pick one versus the other. I hope that's not the case, but so with the healthcare power of attorney, again, we can name as many people as we want. It's one at a time. We want to make sure that we're naming also the right people. So not just that they're willing to make the decision, is it the right people that we're naming? I've got a lot of clients, and I bring this up because it happens so often that I think it's worth bringing up. Inevitably, clients of mine that have adult children, for some reason, the default is always that they're going to pick their kids to step in and act in order of their age. For some reason, I don't know why. So it must be like in every single case, the oldest is the most mature and the youngest is the least mature, or something along those lines. Now, I would say that with my brother and I, that's true. But I've got some half siblings that are older that I would actually argue otherwise. So, I think that in general, we just have to be conscious of picking the right person. And this isn't a popularity contest, right? We shouldn't be afraid of, making our oldest daughter feel bad because our youngest son really is the right person to be named as our healthcare power of attorney. Being named as a power of attorney, I always tell my clients, I'm like, this is not a gift you're giving your children, right? This is not like, oh, yay, if mom gets sick, I get to step in and make medical decisions for her for the rest of her life, right? I know I'm joking, but it's really not a joke. I mean, it's not fun. Right now, there are some adult children. There's some of us that sort of have this controlling nature where, I want to be the one making decisions for my parents. And I might complain about it when the time comes, but I'm going to fight to be that person because I want to do it. Right. And I'm sure we all know people like that. Right. So it's like, yeah, I want to be a power of attorney versus my brother, but I might complain about it later and say that it's so much work, but I still wanted to do it. I didn't want him to do it. So it really should be naming the people that we feel like are the right people or the right person to handle it. It shouldn't be like, I'm worried about hurting my son's feelings if I name my daughter first or vice versa or whatever it is. This is where we get selfish, right? This is where we get selfish because making medical decisions is serious. I don't think any of us would disagree with that. And we want to make sure that we've got people named to the right people named. Hank, is that a question? Can everybody hear me? I just want to make sure everybody can hear me. For some reason, I feel
Yes,
like...
I can hear you, but
okay.
Hank, to unmute, you could also try pressing down on your space bar if you're having
you can press down. You
unmuting.
can press down your space bar and hold it down to unmute yourself temporarily, and then you can release it and you'll go back to mute. Thanks, Marguerite. I was trying to unmute Hank because I saw him trying to raise his hand, but I couldn't. For some reason, it wasn't working. All right. Well, I will get
I have
back.
another question. I've heard some people say you should not name the same person for power of attorney for healthcare and property. Your thoughts?
Well, I will answer that question, and then we'll talk about the property power of attorney. I disagree. I'll just,
Thank you.
without going into any detail, I don't know if it's necessary. I don't.
That makes sense to me.
Yeah.
I mean, again, it's an individual situation, but I know people
Totally.
where that does seem to be the best decision. So
Mhm.
Thank you.
So the other power of attorney that we have in place in Illinois is the property power of attorney. And the property power of attorney is a legal document where we are naming somebody to step in and make decisions for us that are related to everything that's not healthcare. Okay. So it's called the property power of attorney. And I've had some people say, oh, well, I rent an apartment. I don't own any property, so I don't need a property power of attorney. No, not the case. So a property power of attorney is going to step in and really handle everything that's not medical. So this would be, yes, if you own a condo or a house, this person would be able to step in and manage your real estate for you. This person could sign a lease agreement for an apartment. And if there was issues with your lease, even if you're renting an apartment, if there was issues with the lease and you're incapacitated, your power of attorney for property is going to step in and deal with that. Your power of attorney for property is going to sign contracts on your behalf, right? And then all the other things that we can think of: managing your checking account, your savings account, your IRA, your 401k, your life insurance policy, your stocks, your bonds, your brokerage account, your CDs. Your property power of attorney will step in and handle all of those things on your behalf if you're unable to. Your property power of attorney will also deal with things like issues that come up with Medicare or Social Security, filing your tax returns, or issues that come up with the IRS. If you have to apply for Medicaid at some point, your property power of attorney is going to be filing that application. So these are all the types of issues that our property powers of attorney deal with on our behalf. I'm sure we would all agree, a really important document, right? And we want to be really careful about who we name to step in as our agent under the property power of attorney. When we don't have, before I forget to mention this, so what happens when we don't have a power of attorney? And I'll go into more detail on the property power of attorney, but what happens when we don't have powers of attorney in place and we become incapacitated? Ultimately what happens is that somebody close to us typically will have to petition a court to be our guardian. Okay, now for healthcare decisions, there's something called the Healthcare Surrogate Act. Okay, so there is a sort of a default in Illinois that if we are incapacitated and we don't have a healthcare power of attorney, there's this list of people that are close to us that the state of Illinois has determined, and in order, those people can step in and make medical decisions for us. Now, I'm saying this, I am by no means telling anybody here to rely on the Healthcare Surrogate Act. Okay, I am not saying, don't worry, you don't need a healthcare power of attorney. We've got this backup in place and it's great. Absolutely not. I'm going to say the opposite. You should all have healthcare powers of attorney. Okay, it's just that if in fact we don't, there's a backup. It's like me saying, hey, everybody should have a will or a trust, but if you don't, Illinois has a backup plan, and your estate will go through probate, and the state will determine where your assets will be distributed. Okay, the question really what it comes down to is, are these backup plans that the state has determined for us the plan that we want? In some cases, it might work out, it might just happen to work out that the way the state has it laid out for us is what we would have wanted. But in a lot of cases, it probably isn't. It also means that we're probably jumping through more hoops. There's more costs involved. There's more time involved. And those are things that we don't want, right? And that's why we plan. That's why we put documents in place, right? While we still can, while we still have capacity. A little bit about the guardianship process, and I'll be very brief. The reason why I would say that the vast majority of people would want to avoid the guardianship process is that when we have powers of attorney, number one, we're choosing who we want to step in and make medical or non-medical decisions for us. And we're probably, unless we go online and print them off and do them ourselves, which I am also not recommending, we're probably paying an attorney, some sum of money to handle that for us. Now, when we look at a guardianship, we're probably talking about, many multiples of what we would pay an attorney for a power of attorney. We are now going to pay an attorney to handle the guardianship process for us. And between the court costs and the attorney's fees, the guardianship process could be 5, 10, 15 times the cost of putting powers of attorney in place prior. Not to mention the fact that when we have a guardianship in place, you typically need to check in with the court on an annual basis as the guardian to describe what's going on with that person's estate. How's the money being spent? Needing to get permission from the court to sell a house or do things like that. Most of us don't want to have to go through all of that to have somebody make decisions for us. So I'll leave you with that. This is why we put powers of attorney in place. We don't want to deal with these processes. So the power of attorney for property, we can name as many people as we want, like healthcare, and it's one at a time in a specific order. Okay, a lot like healthcare. Now to Marguerite's question, it could be the same order. We might decide, hey, you know what? Realistically, right? Most of us, if we're married, our default is that as long as our spouse has capacity and has the ability to make decisions for us, we typically say, you know what, our spouse, we're going to name each other first. And then after that, if we've got adult children, we're going to name our adult children in some order. And if we don't have adult children, maybe it's nieces or nephews, maybe it's close friends, whoever it might be. The reality is that obviously in some cases, yeah, the people that I list to make medical decisions for me might be the same order of people that I list to make the financial, the non-medical decisions for me under the property power of attorney. But I'll tell you, not in every case. And I'd probably say at least 50% of my clients, the order is not the same for both. And it's because I think we have a strong enough discussion where, we really talk about the idea of who's most appropriate. And somebody might be way more appropriate to make financial decisions, but not as appropriate to make medical decisions. And in some cases, it might be, hey, listen, all 3 of my kids could all be the first person no matter what, because they're all very responsible. They could all totally step into the role of property power of attorney and handle everything that they need to handle. And they could all make medical decisions and they'd all be fine doing it. And they all get along and everybody's great. And so in that case, typically they're going to mix up the order just so that not all of the decision-making falls on one person's shoulders, right? So one thing to consider is, hey, if we've got a few people and they're all very competent, maybe we're going to split it up just because, you know what? I don't want to have my daughter have everything fall on my daughter's shoulders. We'll have my daughter handle the financial piece. We'll have my son handle the medical piece. Right. So again, it's just things like, I'm not saying that people need to rack their brains when putting these documents together, but these are important documents and we should put some thought into it. It's not just signing a form. Okay. If it was, I would be out of business. Right? Because people would just get documents online. They would never work with an attorney if that's what it was. But this is why we discuss these things, because there are things that we need to consider when putting these documents together, even if they are simple documents like powers of attorney. Okay. With the property power of attorney, and similar to health, these documents can actually take effect in one of 2 ways. So they can take effect immediately, or they can take effect only upon a doctor determining that we can no longer make our own decisions. Now for medical, I'd say a lot of married couples will sort of default to this idea of the power of attorney taking effect immediately. A lot of my, let's say my married couples that are maybe like 50 to 60 plus in age. And that's typically because, maybe we're starting to see a doctor a little bit more. Maybe we have things going on and we think that it's really important that our spouse can sort of step in and take part in the decision-making process. Ultimately knowing that at the end of the day, if the decision's for me, my decision is going to overrule my wife's, right? I love her to death, but it's not like if we're arguing in front of a doctor as to what to do, the doctor is going to take her word over mine just because my healthcare power of attorney was effective the day I signed it 8 years ago. Right? It's going to be whatever I want. This typically comes into play, though, a lot with older clients of mine where their adult children are very involved in their lives, and in a good way. There's obviously some adult children that are involved in their parents' lives in a not so good way. But those that are really there supporting their parents, a lot of times my clients will have it effective immediately because their kids are there at the doctor's appointments. They're sometimes talking to the doctor. And in some cases, if mom or dad is starting to slip a little bit, it's helpful that they can have a conversation with the doctor, maybe outside of the presence of their parent, again, with their parent's best interest in mind. So every situation is different. So again, we can have that healthcare power of attorney effective immediately, or, it's not going to be effective until a doctor says, I can't make my own medical decisions. Then it will kick in. With the property power of attorney, we have the same option, right? It can take effect immediately, or it can take effect only upon a doctor putting something in writing saying that I can no longer make my own financial decisions. I'd say that the vast majority of people I work with will make the power of attorney effective immediately. And that's not just in our practice, talking to colleagues of ours. I think at one point, I can tell you that it was much more common for powers of attorney to not take effect until a doctor put something in writing. And that's just because I've got a lot of clients that have powers of attorney that were put in place 20 years ago, and they bring them in and we're updating them, and that's what they say. The idea behind the power of attorney for property taking effect immediately, number one, we should be very trusting of every single person that we've named on a property power of attorney, right? We discussed all of the things that my property power of attorney can do for me, right? Access my IRA, my 401k, every single financial account that I have. So clearly I'm trusting the person I name. And so I always sort of, again, respectfully challenge my clients, because I'll have some clients say, oh, no, there's no way I would want this effective immediately. I wouldn't want my son to have access to my bank accounts. Well, then a red flag goes up to me, right? And I'm like, well, why would you have an issue with him having access to your accounts now, but you would be totally comfortable with him accessing your accounts if you had dementia and you had no idea what was going on with your money anyway? And typically I stump them a little bit, right, for a second. And then for a lot of people, it's just this idea, there's like this sense of being uncomfortable with this idea that, well, while I can still manage my stuff, I don't want my son to have access, or I don't want my daughter to have access. And I totally get that. And there's no right or wrong. And at the end of the day, this is a decision that we all get to make. And I'm not there to pressure people to make one decision over the other. I'm there to really have people think about it. Because again, sort of that first reaction is, oh, I'm not comfortable with that. But then we bring up things like, listen, you might get to a point, think of you getting to a point, and this is hard for us to think about these things, but just think about the idea that you might get to a point where you're not as sharp as you once were. You're not sharp to the point where a doctor is going to put something in writing saying that you can no longer make your own financial decisions. But maybe you're just not wanting to deal with things as much as you once did. You're not as comfortable paying bills. You don't want to sit down with your CPA once a year and go over your tax returns. You don't want to talk to the financial advisor because you know what? It's just a lot for you to deal with and you don't want to deal with it anymore. But you're not incapacitated, and a doctor would not say that you are. And so for those reasons, I typically say it could be helpful for the power of attorney to be effective immediately. Because you know what? If we're trusting of the person that we're naming, then we're trusting that they're not just going to start looking into our bank accounts and taking money and writing checks. If we have that concern, then we shouldn't be naming them. Because if we have dementia or something like that happens, then that person that we're naming could probably access our money and we would have no way to even know about it. I mean, we could, but if we're suffering from some sort of memory loss, we might not really be at a point where we would be aware of it, is what I really mean, right? And so as long as we're very trusting of the people we name, it's just something to consider. I'm not saying it's right or wrong. These are options that we need to think about. Any questions I'm going to move on from powers of attorney, but before I do, I want to ask if anybody has any questions based on what we just talked about.
I just had a comment. That was a great explanation. Thanks again, Matt. So one of my friends, had it set up where her power of attorney for her niece would not kick in for healthcare until, something went south. And her doctor was like a little reluctant to make the call. And eventually then they did have to have like a neuropsych evaluation where the patient was determined to be non-decisional. So I appreciate you explaining those two options. The other question I had is, I have family members who do power of attorney, and they're doing it out of love, and it's a huge job, and they're not charging a fee. For those who wish to charge a fee when it becomes more like a full-time job, what is the guideline on that?
Sure. Yeah. Good. Appreciate the comment, Marguerite, and the question. So I will say that with respect to the comment you made, those are some of the situations where, people do see the value in having the powers of attorney take effect immediately, because doctors, when somebody's memory is starting to slip, I will say that especially a lot of primary care physicians, right? Even if we've got a relationship with them over, 15, 20, 25 years, a lot of times they might be reluctant to put something in writing saying this person lacks capacity. And so again, something to consider. I'm not saying that that's why we should make the power of attorney effective immediately, but just something to consider. As far as, the idea of a power of attorney charging for their time, which is they are allowed to do under the statute, whether you are stepping in as a healthcare agent, okay, so the person named to make medical decisions under a healthcare power of attorney, or an agent under a property power of attorney, you have the ability to charge. As far as what's reasonable, I would say this sort of runs the gamut. I mean, when clients reach out to us and they ask these questions, I typically, I think that in acting as a power of attorney, typically what we would say is, I would say anywhere from $20 to $30, $35 an hour, I think is fairly reasonable. If we start getting into like the $50 and plus range, I'm not really sure about that. If somebody's stepping in and they're acting as an executor of our estate or a trustee of our trust, and there's a lot more work involved, maybe we start to get into that range. But I mean, one thing I will definitely not agree with is so-and-so who's my power of attorney is a lawyer and he charges $300 an hour. So he's saying that he should charge his $300 an hour fee to be a healthcare power of attorney. No way. We're not going to do that. So it really comes down to what we think is reasonable. I mean, I've had clients want to put a number in their power of attorney, and I've pretty much said I'm not willing to put a number in there. Because also we might be talking about somebody stepping in as a power of attorney in 25 years, and what's reasonable now is definitely not going to be reasonable in 25 years. We know that. So, Hank, did you have a question? Yeah.
Yeah, I was just wondering if you could make the power of attorney effective immediately, but only have it utilized for certain, say, financial actions. You'd like your son to handle your income tax or something like that. Is that possible? Kind of pick your spots where the person would use the power of attorney?
Yeah, I like the question. I see where you're going with that. That's a first for me. I don't know exactly. I mean, my gut instinct, I mean, that'd be a good discussion with some colleagues. And my initial reaction would be that I don't see that working. On the power of attorney for property, it's going to be either effective immediately for everything, or it won't be effective immediately for everything. There are some powers of attorney that people will sign that are more limited in nature, a limited power of attorney. Some of you at some point in your lives may have signed one during a closing on a house, right? So you employed a real estate attorney, and in some cases, people will sign limited powers of attorney, allowing their real estate attorney to sign off on all these things on their behalf, so that they don't need to deal with it, and the real estate attorney can handle it for them. And that's just one example. Or a situation where my wife can't make it to the closing, and the real estate attorney gives me a limited power of attorney so that I can sign for her, really just for the purposes of the closing. So we can put something like that in place. The problem with a limited power of attorney, my issue with it typically is that it looks just like a regular property power of attorney. It's just that it's going to be more limited in scope. And if we signed a limited power of attorney, it would revoke any other power of attorney we have, which I would not want to have happen. So without going into a longer discussion with a lot of colleagues, I would suffice it to say that we're probably better off either making a decision one way or the other. Either we're comfortable with the person stepping in and having the ability to make all decisions on our behalf, or we're just simply not comfortable with them doing it until we can't do it.
Yeah, but having the ability to make the decisions doesn't mean that they have to. I mean, if you
Correct. Correct. So that's why. So yeah, to clarify then, so to make sure we're all on the same page, is even though the power of attorney is effective immediately, two things. Number one, that does not mean that I'm giving up my right to make my own decisions. Just to be very clear, I just had this discussion with a client last week who was a little confused about that. Absolutely not. What it does is it allows my agent and just the first person. So even if I've got 4 people named in order, it's still only that first person, right? And it only goes down to the next person if that first person either resigns, is incapacitated, or passes away. Okay. So that if I make it effective immediately, that first person can step in. I mean, the ideal scenario is that I trust this person to only step in if I need them to. Right? Hey, John, you know what? I've got a bunch of bills here at the house. Can you come over and write a bunch of checks and pay my bills? Ideally, we're not having it effective immediately, and then John's just going to go rogue and start accessing my bank account and doing things that I don't want him to do, right? I mean, so the idea is that we're naming somebody that while they have the ability to do it, they're really only going to do it if we need them to.
One other question, not on that exactly, but isn't for either property or medical, if your spouse is in good health and clearly thinking and so on, wouldn't that always be the logical first person in the power of attorney?
Oh, I mean, typically, right? I mean, a lot of us will default in, yes, as long as our spouse has capacity. There's not too many situations that I've run into where the spouses don't name one another, but there are some situations where I've got older clients, and while they both have capacity, you know what? They've basically just decided that, let's just say it's a situation where, the husband was never one to pay bills, was never one to deal with the finances, and the wife always did it. The wife sometimes in those situations is going to name an adult child first and is just going to skip over her husband, and the husband's going to be totally fine with it in most cases. There's not too many situations where the husband's like fighting to be the power of attorney, right? They've talked about it and decided, yeah, I'd rather not do it anyway. Let John do it.
Okay.
So, so yeah, there's definitely a lot of like in estate planning, and when it comes to wills and trusts and powers of attorney, there's a lot of normal, right? This is what's normally done, but that doesn't mean that that's the right way to do it for us, right? We all have very specific situations, right? We all live separate lives and have different family setups, and we have to make sure that whatever we're doing is right for us, right? It's not just because like 90% of people do it this way. Okay, the last couple documents, I guess we are going to use close to an hour, which is good. So the last couple documents, which will be a little quicker. Oh, yeah, Marlene, I'll unmute you.
If you have already your bank accounts, etc., and somebody like one of your children is already on that account that's already taken care of, and let's say your stock and stuff, one of your other children is a representative with your trust at the stock, who is the company that's managing your financial stock accounts. Would just a will be appropriate, and you could specify you'd like this person to be in charge of getting rid of your household furnishings?
So that question, Marlene, is probably a little bit more involved than I have time to answer right now, and it's just a little bit outside the scope of the powers of attorney, starting to get into the wills.
Okay.
Yeah, I'd have to answer that really separately, and I think there's more to it. In general, what I will say though, the aspect that I will answer is that number one, and I think you bring up a good point. I mean, just because we might have an adult child on one of our bank accounts listed as a joint owner, number one, first of all, does not mean that we don't need powers of attorney in place, because if I become incapacitated just because my son is joint on the account with me, I might still want my daughter to step in on my behalf, or whatever that situation might be. So that's one thing to consider. I'm also not, and I won't go into detail on this, I'm also not a huge proponent of adding children on as joint owners onto accounts in general, especially if we have multiple children and we have one child named on an account, because that account then will belong to that child solely upon my passing, even if, let's say, I want my estate to be divided equally. And I think those situations can sometimes get messy. So I'm not going to go any further than that. So Marlene, anything I didn't answer, please either email me or you can give me a call. I'm happy to talk it through with you. But I'm glad you brought that up, because those are some good points and some good things to consider. And, you know, the naming adult children on bank accounts and various accounts we have is something that's so common. And I don't please, you know, I'm not saying that to make anybody wrong. I get it. And in some cases there's a benefit in it. It's just, we have to really pick and choose and understand what we're doing and make sure that we understand the consequences of making those decisions as well. The pros and cons.
That was a great answer also to Marlene's excellent question. But does that also point to the difference between like the role of the executive director, who's now going to take over sort of like executing the will, versus the power of attorney for property?
So executor, not executive director. Yeah, it's okay. Again, a little bit outside the scope, and I'll do it just because for the sake of time, I'm going to give you a really quick answer. But to be very, very brief, a power of attorney for healthcare or property, those only kick in and are applicable during our lifetime. The second I die, my power of attorney for property goes away. So, you know, let's say I don't have anybody joint on my bank account, and I've got, you know, $100,000 in my checking account at Chase. I die. My son, who's power of attorney, does not have access to that money anymore now as power of attorney. And if I have a will, my will, to also kind of see where the will kicks in, a will does nothing for me during my lifetime. The will only kicks in at my death. So basically my power of attorney, you know, manages that account as my power of attorney up to the point I die. And then after I die, then my will kicks in, and my executor is the one that's going to step in and manage all the assets that were in my name. But we'll have other talks where we talk about wills and trusts. And I will also say that this is not through the why, but I don't know why I can't mention this. I do a sort of like an estate planning 101 talk the fourth Thursday of every month at 7:30 at night. I think that Thursday in October and maybe November is going to be a little bit different because of Halloween and Thanksgiving. But if anybody's ever interested in those talks, where I do go into a lot more detail on wills and trusts and the difference between those documents, feel free to shoot me an email. I'm happy to send you the Zoom link for those. So sorry, Karen, if you didn't want me to push that on the YMCA time. So, all right, the last couple documents: HIPAA, living will, POLST. So these are we can be fairly brief with these. So the HIPAA, a lot of us have signed HIPAA authorizations when we go to the doctor's office or we go to the hospital, and really what the HIPAA is, and I always forget what HIPAA stands for, and we don't need to get into that, but really what it is it's the healthcare authorization, right? Who can have access to my medical information and my medical documents and my medical paperwork. So a lot of times when we sign HIPAA authorizations at the hospital or at the doctor's office, it's so that they can pass our medical records back and forth between medical institutions. But a lot of us can sign HIPAAs on our own, where we name people that can have access to our medical records. Okay. Now, some of us may have no interest in putting these together, and that's fine. In our practice, anybody who comes in and puts any kind of an estate plan together, whether we're putting an estate plan based on a will or an estate plan based on kind of based off of a trust, we always include HIPAAs with it. And really the HIPAA, so we can name as many people as we want on the HIPAA. There's no specific order, right? So it's not like the powers of attorney where it's one person at a time in a specific order. So my HIPAA, for example, has my wife, my parents, my in-laws, my siblings. There's really two things that people on my HIPAA can do. Is really what it comes down to. They can have access to my medical records. So anybody on my HIPAA can take a copy of my HIPAA to my doctor and say, hey, I want to see a copy of Matt's medical records. Great, they can do that. So number one, we have to be comfortable with the fact that the people that we've named can do that. Reality is, I'd probably argue for most of us, the people that we would name on there probably could care less about going to our doctor and asking for copies of our medical records. I'm just guessing. I think it's a pretty safe guess to make. But we do have to be comfortable with that. I've had some clients say, ooh, you know what? I don't want to name that person because he's nosy or she's nosy. And you know what? Well, they probably wouldn't do it. I don't want them to do it, even though I have nothing to hide. Great, fine. The reason I really like the HIPAA is for the second part. And that's because if anybody named on my HIPAA can talk to my doctors. You know, let's say there's an emergency and I'm rushed to the hospital, something's going on. Anybody on my HIPAA can call the hospital, find out what's going on, talk to the doctors, talk to the nurses, talk to the staff. That's really why I like the HIPAA. I think that's the most, for me, I think that's the most important reason that we would put a HIPAA in place. Because really the only person, without a HIPAA, the only person that the medical professionals would default to speaking to would be my healthcare power of attorney, which would be my wife. And they wouldn't talk to any, you know, it's not like they would talk to the second person I've named after her, or the third person, or the fourth person. They would only talk to my current healthcare power of attorney. And in the event that I don't have a healthcare power of attorney, they will always, based on Illinois statute, they will always talk to a spouse. They will always give that information to a spouse. But I like the HIPAA because, you know, if something serious happened to me and there was an emergency, I'd rather not have my parents, my in-laws, my siblings all going to my wife and having to get the information from her, right? Inevitably, she's probably dealing with enough. And so I'd rather just have them be able to communicate with the hospital to find out what's going on. That's really the HIPAA in a nutshell. So again, two big things with the HIPAA. There's no specific order. We can name as many people as we want. And there's no decision making. The people that we're naming on HIPAA strictly have access to our information. They are not making decisions. The decision makers are the people we're naming on our healthcare power of attorney. Okay, I just want to make sure that we're very clear there. Then we have the living will. The living will is sort of the do not keep me alive unnecessarily document, right? It's the 1 to 2 page document. Sometimes it's called a declaration. I've seen a lot of older ones where attorneys used to call them declarations. Some attorneys still use that term. We use the term living will. These are not appropriate for everybody, right? For me, it's appropriate because I don't want my life artificially prolonged. So really what the living will does is it acts as more direction to my healthcare power of attorney or to whoever's making medical decisions for me that I do not want my life artificially prolonged. Do what you can to keep me comfortable, but I don't want to be hooked up to machines. I don't want, you know, I don't want you using experimental drugs. I don't want you to freeze me cryogenically to try to save me. If it's my time, it's my time. Keep me comfortable, but let me go. So clearly, if I've got clients that want their lives prolonged to the greatest extent possible, they're not signing living wills. Again, it's one of those things where even though it sort of comes standard in the estate planning, you know, package that we offer to clients, if it's not appropriate, then it's not appropriate, right? And we just don't sign it. But again, I want to be clear. It's really a document that's going to be more direction to our healthcare power of attorney. That this is what we want, that we do not want our lives artificially prolonged. And I like it for that reason. So it's not a controlling document. It's not like the paramedics come to my house, I'm laying on the ground, I'm in cardiac arrest, they see the living will. My living will just happens to be laying on the ground next to me, you know, flip to the signature page. And they say, oh, Matt didn't want his life artificially prolonged. Do away with those paddles, get out of the house, or we're just going to let him go. Not at all, right? They're going to throw that document aside and they're going to put the paddles on me or resuscitate me or do whatever they need to try to bring me back to life. Okay. The living will really is just more direction to those I've named to step in and make medical decisions for me that I don't want my life artificially prolonged, right? So for that healthcare power of attorney, right, he or she should have like 3 different things telling them what I want if I do not want my life artificially prolonged, right? They're going to see the box that I checked on the document. If all my clients do what I ask them to do, they will have had a conversation with that person at some point, and then they will also see my living will that says what I want, right? So we're basically shoving it in our power of attorney's face in a nice way that we don't want our lives artificially prolonged. Okay. The last thing we're going to talk about, so where the living will kind of falls short, there's a document called the Post in Illinois. All right, and many of you probably are more familiar with the term DNR. Right, most of us have heard of the DNR, the Do Not Resuscitate. This has been around for years. Now this is not, I mean, it's a legal document in the sense that it's controlling, but it's not a legal document. A DNR, or what's now called a Post, and I'll explain what it is it's not a document that an attorney prepares. It's a statutory document that Illinois has that we print off online, and we have to have it, filled out and completed with our doctor. Now, it used to be called the DNR. Okay, we can still refer to it as a DNR, and that's fine. But when it was called the DNR, really all it was is we would sign a DNR if we had no pulse and we were not breathing and we did not want to be resuscitated. Then we would sign a DNR. Okay, that's it. But at some point, Illinois decided, you know what? We feel like we need to beef this up a little bit. All right, we need to put a little bit more language in here. And so ultimately what happened is this document called the POLST, P-O-L-S-T. And again, if you want my outline, I'll have a lot more detail in the outline, especially because we've got 5 minutes and I'll be able to pretty much get through it, but I'll be a little bit speedy. The POLST stands for Practitioner's Order for Life-Sustaining Treatment. And really what the POLST does, it's like a DNR on steroids, all right? So there's 3 different sections in the POLST. The first one talks about, do I want to be resuscitated or not? So I can actually say yes or no, right? So it's very clear, because I think it's without a DNR, a lot of times we could argue, I don't know what this person would have wanted, right? If they never put a document in place, ever, no healthcare power of attorney, no nothing, we would have no idea what they wanted. And so in this case, we're either saying, yes, I would like to be resuscitated, I would want CPR, or no, I do not want CPR, right? So that's the first section. The second section talks about sort of like what kind of treatment we would want. I mean, the technical term is orders for pre-arrest emergency. Let's use regular people's terms. What kind of treatment do we want? Do we want sort of like full throttle, right? Do whatever you can to keep me alive. It doesn't matter how, the lack of quality of life I might have, just, keep me alive to keep me alive. Then we have sort of the exact opposite, right? Sort of like comfort care, maximize my comfort, relieve the pain through medication, oxygen, etc. But, I don't want you to use the treatments that you would use in like the full throttle mode, right? No intubation, no mechanical ventilation, or any more invasive means. And then there's sort of like a middle ground, sort of a little bit of gray area with the middle ground, right? The more selective treatment. But this is sort of like I want you to do this, but I wouldn't want you to do that. Okay, so we get to be specific as to sort of like what level of care we'd want. And then the last section talks about artificial nutrition. Right, so medically administered feeding. A lot of times we're kind of thinking of feeding tubes, and with this it's sort of like, do we want no artificial feeding? Are we okay with a feeding tube for a long-term period of time, or are we okay with a feeding tube just for a trial period? Right, yeah, I'd be okay with it for like a week or 2 or a month, but if I have to live the rest of my life with artificial nutrition, that's the only way to keep me alive. It's not what I want, right? Some people just may not want that. It is all about what we want. I'm going to just give a disclaimer. I've got 2 minutes left, and I really do have to cut it off at 10:15. I apologize. So I'm not going to take any more questions. If you have questions, you can email me. Sorry in advance. I just want to kind of wrap up the POLST really quick. So the POLST is, because clients always ask me about it, and I always say, respectfully, I'm like, it's not something that you're going to do with me. Typically, we're going to fill this out a lot of times in a doctor's office, and here's why, right? So as far as who signs a POLST, and I didn't even talk about the powers of attorney, so I will wrap up on that as far as how to sign those. But for the POLST, it's either I can sign it or my healthcare power of attorney can sign it. So if I do have a healthcare power of attorney in place, he or she can sign it. It needs to be witnessed, and it needs to be signed by either a physician, an advanced practice nurse, a physician's assistant, or a licensed resident who's completed at least 1 year in a program. And so what's really important is that, when the POLST came out, it was actually, the P stood for physician. And so as far as, who could sign it, it had to be a physician. Well, we probably know that doctors are really busy and it's hard to get a doctor to sit down and maybe go through something like this that's not necessarily related to our immediate needs of healthcare. And so they kind of expanded, who could sign this document. And so they've included some of these other individuals. I want to just go back to powers of attorney real quick and just wrap up just so we know who needs to sign powers of attorney to make them effective. Okay, so for a healthcare power of attorney in Illinois, for it to be effective, it's signed by me, the principal, if it's my power of attorney, and one witness. The witness cannot be anybody that I've named as an agent on the document, and that cannot be anybody that's related to me by blood or marriage. And it also shouldn't be anybody that's treating me in any kind of healthcare capacity. So my witness cannot be my nurse or my doctor. The property power of attorney, same parameters as far as who can be a witness and who can't, needs one witness and a notary. Okay, so the big difference between the healthcare power of attorney and the property power of attorney is that we also need a notary. And they need to be separate people. Okay, so the witness cannot also be the person notarizing. They need to be separate. With that said, it's 10:15. I truly have gotten through all the information that I planned on covering. I appreciated all the questions that everybody had. These questions always help the entire group, so those are very much appreciated. So if you do look at the chat box, I do have my information in there. The name of my firm is Margolis Weldon. You can look us up online. You can get my information there as well. If you have any questions, you can reach out. Like Karen said, I do this the first Wednesday of every month at 9:15. It's always a different topic. There's definitely a lot of overlap. So, aspects of what we talked about today might come into play at another talk. Just the nature of what it is. I wish I had 12 presentations of very, very different information. It's just not the case. And there just tends to be some overlap. So I appreciate everybody's time, your attention, your questions. Stay healthy, stay safe, take care of yourselves. And thanks again for joining us this morning.
Thank you.
Signing out.
Thank you for what you do for us.
You're very welcome.
We appreciate that.
I appreciate that. Thank you.